I want to thank the organizers of this experience sharing platform. It's good to speak at the end because you find that everyone has said what is supposed to be said. And just as well, my superiors have gone before me. And they've talked about the legal framework and the measures that the nation is putting in place to combat human trafficking and related cases. Then my task is simple. I'll just give an example of a case that the subordinate court handled, and I'll highlight a few challenges that the subordinate courts as trial courts face in human trafficking and related cases. And what I noticed is that my colleagues from Kenya, in particular Christine and Helen, talked about some of these challenges, and I think the challenges are common. So I'll just talk about a case and then highlight some of the challenges. So in the case of the people versus Kayembembike, a case of 2015, the accused person in this case was a Congolese national, but he was resident in Zambia. This person was charged with offenses of being in possession of fraudulent identity documents, contrary to Section 9, Subsection 3 of the Anti-Human Trafficking Act number 11 of 2008 of the laws of Zambia. The second count was attempting to commit an offense contrary to Section 12 of the Anti-Human Trafficking Act number 11 of the laws of Zambia. And he attempted to smuggle 5 Congolese nationals comprising of 1 female and 4 males aged between 23 and 36 years. And with the third count, he was charged with making documents without authority, contrary to Section 356A of the Penal Code, Chapter 87 of the laws of Zambia. The documents which were involved in this case were an identity card of, an employee identity card of the Embassy of the United States of America, purporting that the accused was an employee of that embassy. The accused in this case pleaded not guilty, and the prosecution called 7 witnesses. But I'll just try to summarize what the first witness said in relating it to human trafficking. So this was a female victim, and she stated that whilst in Congo, DR, her elder brother told her that the accused, a travel agent based in Lusaka, Zambia, that is the capital city of Zambia, could facilitate her travel to the United States of America, where she would get free education and money. Her brother then brought her to Lusaka, and he used a valid Congolese passport and a valid Zambian visa, and he left the sister with his friend. Thereafter, the accused person got her passport indicating that he was going to have the days of her stay in Zambia extended by immigration officers. Later, the accused took her to the airport, that is where the accused, who still had her passport, because after taking it for the extension of days, he did not give it back to the lady. And he still had his passport, and he took her to the airport, and he presented her passport and other passports to the authorities, that is the immigration officers. And to her surprise, she was later apprehended together with other people in connection with the subject charges. She also said that she did not have friends or relatives in the USA, but that in facilitating her travel to the country, the accused had told her that once she was in the USA, The Americans would welcome her, give her free education, and thereafter a job. So this accused person was convicted. Of course, looking at the evidence of the 7 witnesses, he was found with a case to answer, and consequently, he was convicted. And seeing that the minimum sentences are more than the jurisdiction of the subordinate court, this accused person was committed to the High Court for sentencing. So you can see that we have cases that have been adjudicated on and successfully completed. And when this case went to the High Court, of course, the High Court analyzed the evidence as Honorable Mrs. Justice Bobo Banda stated on the supervisory jurisdiction that the High Court has on the subordinate court. The evidence was revealed, and the High Court sentenced this accused person. So in terms of, yes, the High Court sentenced, and if you look at the act, the judge here has talked about the sentences. Our sentences are very stiff. In terms of challenges, like I stated, the challenges are quite common. One of them is poor investigations and preparation of evidence. So in some cases, you find that investigations are not done properly. The prosecution will leave a lot of gaps in the evidence, and that can result in defeating justice. I'll give an example of the case that I handled, that is the People versus Zawadi Shonde William and others. It's a case of 2016, where one Tanzanian national, that is a female, and 2 Zambians were jointly charged for facilitating trafficking of 75 Ethiopians and being in charge of a conveyance which facilitates offenses under the Anti-Human Trafficking Act. In this case, the state did not call the arresting officer to connect the pieces of evidence which were hanging and the accused persons to the offense. They also omitted to call a number of witnesses which defeated justice at the end of the day. The other challenge is language impediment. Most of the victims of trafficking come from Ethiopia, Somalia, Democratic Republic of Congo, and Tanzania. These countries are not English-speaking like Zambia. And in some instances, you find that the judiciary does not have interpreters for some of these languages, and we end up outsourcing. And usually, these interpreters, you find that they have other things to do because interpretation is not a full-time job for them. So they'll end up missing some sittings. And as a result, you have quite a number of adjournments. And in this particular case, the victims, like I stated, were Ethiopians. And for us to secure an interpreter, it was very difficult. And I ended up adjourning this case on several occasions. And because of these adjournments, the witnesses who were trafficked ended up going on hunger strike. So I received a lot of pressure. These people were in prison, 75 of them, and they just stopped eating. So that was pressure. Somehow we had to find a solution. So these are some of the challenges. So somehow I had to allocate a number of dates for this matter so that we can conclude and they can go home. And then there are cases where interpreters were not secured at all. Like in the case of the People versus Wenford Piri and 27 others, it's a case of 2014, where 28 Somalians were charged with the offense of consenting to being smuggled. The state had to withdraw the case against the accused persons because they could not find an interpreter within a reasonable time. The other challenge is lack of housing facilities for witnesses who are victims. The Act in Section 40 provides for the establishment of centers for victims by the minister in charge of social welfare. However, no center has been established currently, and as you heard from the judge, that measures are being put in place, and we are positive that something will be done. But due to lack of facilities, the victims, who are key witnesses in most instances, are kept in prison. Like I stated, the 75 were kept in prison. And considering the harsh conditions in our prison, the witnesses are usually impatient with long trials, which may compromise their evidence. All the witnesses want is to testify so that they can go back to their countries. And the witnesses who are victims also get to interact with the accused persons who are remanded in custody due to failure to meet bail conditions. This also compromises the witnesses and defeats justice. In the above case, the witnesses were housed in the same prison with the accused persons before they were released on bail, and the witnesses complained on several occasions of being threatened by the accused persons. Also, one of the victims was housed at a lodge somewhere within Lusaka, and this victim came and testified, and the case was adjourned for cross-examination. And on the date set for cross-examination, the state could not bring the witness, and they explained that the witness had escaped. This juvenile was coming from Ethiopia, and they could not find him in the country. So it's whereby you have, and his evidence was very interesting, because this is a boy who said that he was kept at a house in one of the compounds, and it's like his movements were restricted, he was locked, he was not even given an opportunity to go to the toilet. This lady just brought a pot for him to use. So his evidence was very interesting, but at the end of the day, his evidence was not tested, so it was very difficult to rely on his evidence. The other challenge is lack of independent witnesses in these human trafficking cases, because you find that the only people that are there are the agents, they call them the agents, and the victims themselves. So at some point you find that the victims are also charged, and then due to lack of witnesses, they are turned into witnesses for the state. And where they are turned into witnesses for the state, their evidence has to be corroborated at the end of the day. And for the state to find evidence, now independent evidence to support their evidence, it becomes a challenge. So in conclusion, it is clear that the subordinate court has challenges in trying human trafficking and organized crimes. And to overcome the challenges highlighted, Zambia has taken steps, as stated by my superior, and however, much more has to be done to ensure that justice is delivered. Thank you very much.
Thank you very much. I just have a quick question, because on the last point you raised, do I understand you correctly that under Zambian law, it may not be possible to convict an accused solely based on one witness testimony? Is that correct? Or you need corroboration of the witness statement? Or is that a misunderstanding?
Under Zambian law, you can convict on the evidence of one witness. You do not need corroboration in all cases. But what she was saying was that where witnesses or victims are also arrested for an offense, then they become, if they're going to be used as witnesses, they become suspect witnesses. So you need independent evidence to support what they are saying to the court. So that is where the challenge is. This is why earlier I was saying that under the Anti-Human Trafficking Act of Zambia, you cannot charge a victim with an offense under the act without the consent in writing of the Director of Public Prosecutions. Because once they decide to charge the victim, they are not going to have a witness. They are going to have a witness, but the evidence of the witness will need to be corroborated by independent evidence. And this is what she's saying, that sometimes it's very difficult to find an independent witness. Thank you.
Okay, then I understood correctly, but that is a severe difficulty under Zambian law, then, that maybe should be addressed in the future legislatively, I may add. Okay.